And we will go ahead and take up Representative Schlegel's bill. It's House Bill 77. Welcome to the Commerce Committee, Representative Schlegel. We're going to let's see Kelly read it into the Miss Kelly read it into the record.
Okay, thank you, Madam Chair, members. This is House Bill 77 by Representative Schlegel. It is relative to liability for publishers and distributors of material harmful to minors, to provide for the investigation and pursuit of actions by the Attorney General, to provide for civil penalties for failure to perform age verification, to provide for attorney's fees and court costs, to provide for exceptions, for definitions, and to provide for related matters.
All right. And Representative Schlegel, thank you for being here. And we know that you have to step away early today, so we wanted to take Representative Schlegel first so that she can get to family first, her most important part of her life.
Thank you, Madam Chairman, and thank you, committee members. I know you all didn't have the luxury of sitting through HB 140 because that went to civil law, but HB 77 tracks very similar to last year's age verification law that passed overwhelmingly in our body. But so what HB 77 does, it also gives the Office of the Attorney General the ability to pursue civil penalties against commercial entities who are currently not following the Louisiana age verification law that we passed to protect children from material harmful to minors. So currently what we have is some companies are complying and some are not. So when you actually look at like all the large pornography websites, and just to use a comparison, so like the Amazon of pornography is complying where Walmart and Target are not. And that's a really poor comparison because Walmart and Target are actually ethical, responsible companies. And so what we want to do here is help bring better enforcement to our law to help better comply to protect children. So that's what HB 77 does. And if you have any questions, I'll be more than happy to answer.
Wonderful. Okay, Representative Newell.
Good morning. Thank you, Madam Chair. Good morning, Representative Schlegel.
Hello.
I appreciate the steps that you have taken to protect the minors, which we all know is an extremely important goal. However, I don't want us to go through and push through legislation which might be kind of overbroad and vague in its actions and its consequences. And because I can tell you that your protections have made a difference. I've gotten lots of phone calls telling me I have prohibited people from doing their pleasures. So it's working in some instances. But which sites are you now trying to change? Because sites that are started outside of the state don't necessarily have to abide by all of our laws if they're created outside. So again, which sites and publishers do you believe would be liable under this law?
Sure. So if you go into some of the large pornography sites, actually some of the ones that aren't complying are actually the most egregious. Those same companies are actually being sued right now for issues like allowing users to upload child pornography or allowing people's actual rape videos to be uploaded to their website or voyeuristic videos to be up. So these companies are currently being sued already. That's actually what gave me the idea for the law to do civil penalties. And so I would have to disagree with your assessment that this is overly broad or vague. This is actually a very narrowly tailored bill. I mean, that's why we have the substantial portion of material harmful to minor on websites, because we want to obviously capture those who are purveyors of pornography. So I would suggest that this is not an overly broad. When we looked at these laws, we wanted to make sure we didn't run into any constitutional issues that other laws did where they were vague and overbroad and captured maybe a bookstore that would inadvertently have a book on their website. So so we're trying to capture those who are just pretty much like, we're just not going to follow with this law.
And thank you for trying to test my experience and education as an attorney with narrowly tailored, because it's not. Because this does not explain the definition of material harmful to minors. You do have a part where touches at that, but it doesn't go into extreme detail as to what exactly is harmful to minors. We do have legislation that's trying to ban books, and I was privy to review one of the books that was narrowly tailored, but one of the books that was brought up as discussion as far as the reasoning behind banning books. But my assessment of that book was educational.
This bill has nothing to do with banning books or libraries.
I did not say it did.
Specifically,
I was giving an example.
Well, I just want to correct the record for that.
We are not talking about books.
Right.
Thank you very much.
We're talking about commercial entities that have a majority of pornography on their websites.
I'm not going to talk over you, so thank you. So this doesn't describe what's what's material harmful to minors. Because are we going to then take sites that have education, sexual education, will that grab this in? Would that put that in here as well? Because you don't have the definition. I did read your bill, and I did see where it says about educational, but how do you define materials harmful to minors to make sure that sites that are beneficial for educational purposes are not scooped up in this, and then someone could come by and call the AG's office and say this is harmful to minors?
Okay, so let me clarify a few things. So this actually does have a very good description of what material harmful to minor is. This is from the Miller test. So you're looking at both A, B, and C, which are all, but for decades the Miller test has been upheld by the courts. So this is very specific on what we're talking about. We're not talking about educational websites. And again, if a school has a website that 33% of their online is pornography, then that would be included in this. We're only talking about commercial entities. I'm not talking about public schools. We're talking about commercial entities that have a substantial portion of pornography on the internet.
Okay, and that was another question I had, because at the beginning you did say commercial entities on the internet, let's see, from websites. However, when we go deeper into it, the commercial entities for websites that's not continuous. So it just says any commercial entity that violates this subsection. Was it not suggested that we could be consistent with that language throughout to say commercial entities on websites, internet from websites, so that we're not grasping all commercial entities?
We're not grabbing all commercial entities. These are for entities that have at least a substantial portion of material harmful to minors onto their website.
I saw that in one part at the beginning. I just want to make sure that this can't be used with any attorney general, because as we know, we're going to get a new one next year, and we want to make sure that you have the proper guidelines in place so that what is deemed as inappropriate doesn't change from administration to administration, so that whatever your goal is consistent with no matter who's in office, and that people can't just say any commercial entity is violating this and then has this civil liability.
No, I understand. That bill is, like, again, it's not going to be broad. It's very narrowly tailored, where it tracks with the other language of the other bill, where it's substantial portion of material harmful to minors. It's not just any commercial entity. Again, these websites are purveyors of pornography. It's not any AG is going to just be able to do whatever they want. Again, it's very narrowly tailored.
Okay, I understand what you're saying, but what you're saying is different than what I'm reading and from my understanding. And for me, it's still unclear as to the provision of what's going to be, which companies are going to have the civil liability, which companies that the AG can go after. And again, I appreciate you trying to protect our minors. Just to me, what I have read, it's not that clear and cutting to the point as what you want it to be.
Can I read? I mean, obviously, the first A, any commercial entity that knowingly and intentionally publishes and distributes material harmful to minors on their internet from a website that contains a substantial portion of such material shall be subject to civil fines and provided. This is not just any commercial entity. This is very specific. And again, it tracks very well with Act 440 that everyone knows and that's why the ones that are actually big purveyors of pornography are the ones complying with age verification and not just some bookstore or another entity.
Okay. Again, I read your bill and I'm listening to you. I'm still not comfortable with it, but thank you very much.
Okay, thank you so much.
Representative Schlegel.
Yes.
I'm trying to figure out.
Oh, it's okay.
And I don't think the microphone is on, but you have some amendments, so we'd like to take up the amendments right now.
All right, thank you, Representative Thomas. We have two sets of amendments. The first set is Amendment Set 984. It is online and it is also in your folders. There is one amendment in this set that adds to news gathering organizations, radio and television broadcast stations, cable television operators, and wire services in addition to their employees. The second set of amendments is set 10. Okay.
Okay. So is there any objection to this first set of amendments? Seeing or hearing none, they are adopted. Yes. I move to adopt.
Okay. The
And
second set of amendments is set 1028. It is also in your folders and it is online. This set is technical amendments, and there are 8 technical amendments, which include the naming of the chapter, the proposed chapter.
is there any objection to these amendments? I move to approve the amendments, seeing and hearing no objection. I think Rep. Tarver was next. Let me turn you on.
Off. There it goes. Okay. Thank you, Madam Acting Chairman. When it's appropriate, I'd like to move favorably. When we get down the line, I'd like to do that. But I wanted to thank Representative Schlegel for your faithfulness in this endeavor. But I wanted to clear up one thing, like you were saying, clear it up. I know when you and I talked earlier about your references to Walmart and Amazon and Target, I just want to make sure that we know that's not who we're talking about. You just use that in a generic reference.
Use that in a very generic and very poor analogy, but just to sort of, and to
Context.
go back, just to bring more clarity to what we're talking about commercial entities. So it not only states about commercial entities having a substantial portion of material harmful to minor, it defines that at the end of the bill where it says it means that more than 33 1/3% of total material on a website, which meets the definition of material harmful to minors. So these are the only commercial entities that would be captured under this bill. It is exactly like Act 440 that we overwhelmingly passed. It's just giving the AG the authority to put civil penalties for companies that are just going to be like, I'm just not going to comply with our law.
Yeah,
So,
I just want to make sure.
okay,
we
we're not
use
talking
the
about
wrong
Walmart
people.
or
Right.
Target.
Thank you. Thank you very much.
No, thanks.
Hopefully not. Okay, Representative Jordan. No. Okay, the board is clear. Let me go ahead and read the cards that we have in support. All right, we have Christy Cross with LA Wallet in support. Ryan Template with LA Wallet in support. Alton Ashley with LA Wallet in support. And Gene Mills with the Louisiana Family Forum in support. We do have some cards in opposition. I'll go ahead and read those now, and if anyone would like to speak, just make your way up to the table. I'll ask Representative Schlegel to just come up here and take a seat. Monique Blossom, representing herself. Britton Forsyth, Step Up for Action. Imani Crenshaw, Planned Parenthood. Angela Adkins, 10,000 Women, Louisiana. Melissa Flournoy, 10,000 Women, Louisiana. Debbie Randall Apcar, 10,000 Women, Louisiana. Casey Carr, 10,000 Women, and now Baton Rouge. Peyton Rose Michelle, Louisiana Trans Advocates. Pearl Ricks, representing herself. Jenny Hastings, TBR. Chris Kaiser, ACLU of Louisiana. Peter Robbins Brown, Louisiana Progress Action, sorry. Caitlin Mathern, WBR. Mary Pritchard, 10,000 Women. Helen Frink herself. Jamila Johnson herself. Carmen McCoy, Lift Louisiana. Kay Channing, 10,000 Women. Amanda Anderson, Reproductive Freedom Acadiana. Jennifer Schmidman. Hopefully I'm pronouncing y'all's names correctly. I apologize if I'm not. Representing herself. Emily Krupp, 10,000 Women. Jeramisha Warner, PPGC and 10,000 Women. Amanda Jones, 10,000 Women. Caitlin Williams, 10,000 Women, Louisiana. Anika Vanderspeak, Lift, Louisiana. Andrea Pickoff, District 65, maybe. Michelle Ehrenberg, Lift, Louisiana. And we did get one email in opposition, and then that's in the record. All right, Ms. Flournoy.
Great.
Welcome to the committee.
Thank you, Representative Davis. I'm Melissa Flournoy. I'm the board chair of 10,000 Women Louisiana. I want to thank Representative Schlegel for all of her efforts to protect children, but I do have some concerns, and I'm here to speak against House Bill 77. In reviewing the legislation, I always ask, is the bill necessary? And in the 2022 legislative session, you passed House Bill 142, which became Act 440. That bill created liability for publishers of pornography and required age verification software for access to materials and provided a process for civil penalties. Based on reading House Bill 77, it's not apparent why this legislation is needed unless it's a backdoor effort to give the Attorney General's office more authority to raise money through fines and fees to expand his office. House Bill 77 does add significant financial penalties and expands the authority of the Attorney General to investigate alleged violations. The current law provides the opportunity for the Attorney General to investigate. House Bill 77 creates a new fee or fine of $5,000 a day for each violation to be paid to the Department of Justice in order to fund the investigation of cyber crimes involving the exploitation of children. The legislation also allows the Attorney General to request the court to impose an additional penalty of $10,000 a day to be paid to the Department of Justice. Here are our concerns. Is this bill necessary to protect children? Does this bill add similar language in a different section of the law to cover the same offenses as covered under Act 440? Why and to what purpose will this accomplish other than generating a reason for the Attorney General's office to pursue efforts of additional fines and fees? Our basic concern, and I think Representative Schlegel addressed this, but we do want to be specific, is this bill part of a larger strategy to promote censorship and limit access to publicly available information, including R-rated movies shown on cable TV and streaming services? What is the unintended or intended purpose of this legislation? We all agree we want to protect children. One of my concerns is, could this legislation be construed to limit access to educational materials on health sites, such as the Mayo Clinic website, Sex Education, Talking to Your Teen About Sex? Would the author consider an amendment to clarify that this legislation does not apply to nonprofit healthcare and education providers who provide access to information on medically accurate health information? Given the heightened political environment and concerns about censorship, book bans, efforts to limit access to information regarding sex education, LGBT-related issues. Would the author clarify the intention of the bill and why this legislation is necessary, and state for the record that this legislation is not intended to limit access to medically accurate health information? We're in a very politically fraught period here in this legislative session, with discussions around banning books, limiting access to information, assailing the rights of LGBT people, questioning the rights of books. We want to make sure that this legislation does not cover nonprofit organizations, healthcare providers, and others who may have medically accurate health information on their websites. Last year, the legislature limited access to pornography and related material and added the age verification process for all websites. We question whether or not this bill is necessary or if it's just intended to expand the Office of the Attorney General and to add burdensome fees to non-compliant commercial providers. The challenges facing Louisiana are significant. In order to address the systemic challenges of poverty, substance abuse, crime, we have to investigate and believe in investing in families, neighborhoods, and supports. We don't want to be derailed by issues around book bans, censorships, and attacks on certain people in our state. We hope that you will amend the bill to protect health educators, medical professionals, and educational websites that are intended to provide accurate health information. Thank you.
Good morning, everyone. My name is Peyton Rose Michelle. I'm the Executive Director of Louisiana Trans Advocates. And today I'm here to ask you to oppose HB 77. I'm born and raised in Louisiana, and I was taught that Louisiana values freedoms, especially the First Amendment and Second Amendment freedoms, and I believe that this bill would potentially infringe upon the freedom of speech of many organizations. The bill does say that it is any corporation that has 33% of material harmful to minors would be included. It does not say just certain kinds of websites or certain kind of corporations. It does allow any corporation to be included. I also would urge y'all to think about how would one even begin to quantify 33% of a website. Websites can be vast and have large amounts of information, and I would imagine that it would cost a lot of money to even begin to quantify the amount of pages on any given website. And ultimately, Representative Schlegel acknowledged the dangers of having overly broad bills and how they could be, used in ways that are not necessarily the intention of the bill author. I would encourage her to maybe explore amending the bill so it is less broad, to, work with the value that I think me and Rep. Schlegel both have. And ultimately, the Attorney General should not be trying to infringe upon anyone's freedom of speech. I ask you all to oppose HB 77, and I thank you all for your time. Thank you.
Thank you so much for your testimony.
Good morning, everyone. Thank you for your time. I am speaking in opposition of HB 77. I just wanted to come up and share a couple of bullet points of how I believe this will impact individuals in Louisiana, organizations in Louisiana, as well as young people and their access to education. HB 77 provides a violation of freedom of speech and gross restriction of knowledge entering the marketplace. It's a clear intrusion of civil liberties that will undoubtedly be brought before the courts, costing state taxpayers dollars to defend something that no constituent can support. It leaves open a backdoor to the denial of access to vital information around bodies and human experience. While I understand wanting to safeguard children and young people from pornography, I believe that there is a more intentional and clear way of doing this. In the legislation currently, the definition of material harmful to children is laid out in, I believe, A, B, and C. However, if we exchange that with the word pornography, I believe this bill still carries out the desire that Schlegel wants to see happen. I think that the definition of material harmful to children is going to be a backdoor to censorship. I believe it'll cut off young people and some adults that may not have documentation for various reasons from sexual education information, from gender information, and information around STIs, STDs, and pregnancy. Nudity, sex, and sometimes the simulation of normal sexual acts through different tools is a way that we can teach young people what happens when you're sexually active. When I was young, I was fortunate enough to have a program available to me that encouraged me to look for information about how my body operated. This allowed me to understand what happened when I was sexually active when I was younger, how to protect myself, and how to protect my peers. Access to that information was vital for my survival and for the health of my community. This bill can do what Schlegel would like it to do, what Representative Schlegel would like it to do. However, I think it's very important that we remove material harmful to minors and replace it with pornography, which has its own definition. Representative Schlegel said just the other day, if pornography companies refuse to be responsible, then we must hold them accountable. It is important that we hold those companies and those companies alone accountable. With this type of language, nonprofit organizations, educational organizations, and groups like parent-teacher groups wouldn't be able to release information that they deem appropriate or deem necessary for their populations. And I would like to say that I agree with Peyton Rose in the quantification of 33% of a website, as I'm curious if that would also involve titles, menus, or landing pages and the information there within. I really appreciate everyone's time, and I hope that you bring these points to heart and to home as you're voting, and I oppose HB 77.
Thank you for testifying. Can you identify yourself for the record?
Yes, my name is Pearl Ricks. My pronouns are they, them.
Thank you. We appreciate it.
Yes.
All right, wait, we do have a question for Rep. Jordan.
Yeah, my question is for Ms. Flournoy. Some of the things she brought up.
Oh, yeah, thanks. Appreciate it. Thank you. I would have gone mad if I'd lost my phone. Yes, sir, Representative Jefferson.
Jordan.
Jordan, I'm sorry.
That's all right. Look, I understand what you're saying, and I certainly don't necessarily agree with the proposed amendment that you had. But two questions. When I'm looking at the bill, as it relates to the AG, I think in there somewhere that he's given like a 30-day provision for these commercial entities to comply before there are any penalties. Does that alleviate any of your concerns on that?
No, sir. I really would like there to be clarification that this doesn't apply to nonprofit healthcare, educational, and medical providers, because I do agree with the previous speaker, the material harmful to minors.
No, but let's go to that. When they talk about that, the only other thing I questioned, and I understand the broadness of it, but in this aspect, I don't know if it doesn't help your position, where it says taken as a whole, lacks serious literary, artistic, political, or the last part, scientific value. I would think, in my opinion, that medical accurate information would have scientific value.
I believe it would. I just hate to admit that I really don't have confidence in the narrow interpretation of the legislation and feel that its broadness could be used to cause concern to healthcare providers and educational sites. I think the question around what is taken harmful to minors, we're seeing this discussion play out in library boards and school boards around the state around what's harmful to minors, around medically accurate health information, around literature, around books, around censorship. I know that's not the intent of this bill, and I appreciate Representative Schlegel, but I just am really concerned that we're creating an open door to further censorship issues around other types of information and giving a cause of action to the Attorney General. And as was mentioned earlier, we may trust the current Attorney General. We don't know who the next Attorney Generals will be. And so I guess I have a very clear concern about ensuring that this is intended strictly for pornographic sites. And so if you changed harmful to minors to pornographic sites, that would address some of my concerns as well. I'm concerned that we've opened the door in a broader community conversation around what types of information are harmful to children and minors. Given some of the dialogue at library boards around the state, concerns about information about children's books or material targeted towards adolescents and high school age children, I'm afraid that there are those that would make a case that more generally acceptable medical information could be considered harmful to minors. And so I would like to be as specific as possible to narrow the implications of this legislation. Because frankly, we all agree, we don't want young people accessing pornography. One of the things that's been most shocking to me is because everybody now has one of these in their pockets, so many young people are exposed to so much way too early. We have adolescent young boys, essentially addicted to pornography. I understand, the need for and the problems we're trying to address. I just don't want us to create or broaden this to create some unintended consequences. So that's
agree.
sort of my basic concern.
I agree with I don't want to create unintended consequences either, but I'm just wondering the way that it's I guess in my mind, as especially when you talk about scientific value, if the broadness doesn't help your position, but
I question the need for this bill because you already passed practically unanimously last year House Bill 142, which is now Act 440. And I don't understand why this bill doesn't just go in and say, as part of that, we want to now add fines, penalties, and fees of $5,000. I don't know why this bill isn't a one-paragraph bill about adding fines and fees. If that's the intent of the author, then the rest of this language is generally unnecessary and redundant to the legislation that was passed last year. That's why I lack confidence that this bill really is limited to its stated intent, because the language that's included in it is already part of current law in Act 440. Are y'all tracking with me? I can read you the information from Act 440, which defines commercial entity, which defines pornography, which page upon page. So I just don't feel that this bill is necessary or appropriate or needed to accomplish the task. The only thing this bill does is to give the power of the Attorney General to fine internet providers $5,000 a day and to expand this definition of what's harmful to children. And so words have consequences, and so that's really what our biggest concern is today.
All right, thank you.
Thank you.
Thank you. Before I forget, I was just handed another card in opposition. Katie Hunter Laurie with Louisiana Survivors for Reform. Right. Thank you. And don't forget to state your name for the record. Thank you.
Sure. My name is Angela Adkins. I am the executive director of 10,000 Women Louisiana. And I won't go over some of the points that the other speakers made, but I do wonder about a couple of things in this bill. Under Section D, Section 4A, what is the definition of sex? That is a very general and broad term, sex. Are we talking about male, female? Are we talking about the act of sex? Are we talking, what is the definition of sex in this bill? Under B, patently offensive way with respect to what is suitable for minors. Who's deciding what is suitable for minors? Shouldn't that be up to the parents that are raising them, or their families, or their grandparents? What is offensive to you may not be offensive to me. I think that children should be made aware of their bodies, their bodily functions at an appropriate age, but at an early enough age to where we don't end up with the high rate of teen pregnancy that we have in the state of Louisiana because we lack sex education for minors that are already having sex. Under Section C, taken as a whole, lacks serious literary, artistic, political, or scientific value as to minors. Who's deciding that? I think this bill is extremely broad. It does open the door to an attorney general who is already on a witch hunt for banning books and other information in the state of Louisiana, who's also encouraging people to turn in other people to be held liable for somebody's ambiguous thought of what is appropriate for minors. This is not something that you can necessarily legislate. Yes, we should keep very harmful things out of the reach of children, but parents should also have the right to decide what is in the best interest of their children and what is appropriate for their children. Thank you.
Thank you. All right, members, the board is clear, so I'll ask Representative Schlegel if she'll come up and okay. And I'm sure she will address some of those concerns and close on her bill. Real quick, I do have another card that was put in opposition. I apologize, I cannot read the first name, but it's Hamilton. So Mr. and Mrs. Hamilton with SGF. So there you go. Thank you. All right, Representative Schlegel.
Thank you, Madam Chairman, committee members. So just want to let you all know this bill tracks exactly with the language of Act 440, which we passed almost unanimously. It was crafted to pass constitutional muster, so it includes language like the Miller test, who has decades long of describing what is obscenity. It's also very narrowly tailored to commercial entities that have a substantial portion of material harmful to minors on their website. It has to be a 33 1/3%. And like Rep. Jordan pointed out on the Miller test is what helps define obscenity. So yes, it's not going to include anything that lacks scientific value. This is obscenity. This is, I went onto these websites before I came and testified just to make sure that they didn't all of a sudden start to comply. And on their landing page, this is hardcore pornography. This is not your dad's Playboy. This is hardcore pornography where research shows 90% of them is aggressive towards women. And so this is what we're trying to protect our children from. And why it's necessary is because, like I said, some are complying and some are not. And that's totally unfair, right? So some just decided, yeah, we're just not going to comply. And so this allows the AG to bring a little bit more teeth into the bill. And again, I know that we've got people who came to testify and are trying to conflate issues. This has nothing to do with books or any other cultural conversation that we're having. This literally has to do with protecting children from hardcore pornography on the internet from commercial entities that have a substantial portion of it. And so that's what the bill does, and I ask for favorable passage.
Okay, Representative Jordan.
Representative Schlegel, look, I know we talked earlier, and I don't have any problem with some of the stuff you said in the Miller test, so I was able to look that up, and I feel assured in that. However, to Ms. Flournoy's point, I did go back and I'm looking at 440 right now, and just part of my concern with that is we have two different definitions of material harmful to minors. So in this one, you talk about, in your current bill 77, we talk about material harmful to minors, and we have 1, 2, 3 things outlined, I guess. And then you go to Act 440, and you have some of that, but then it's a little bit more specific. And I think maybe that's part of the concern that, and I don't want to speak for my colleagues, but I think that may be part of the concern that some of them have, because you talk about material harmful to minors. Any of the following material that exploits is devoted to or principally consists of descriptions of actual, simulated, or animated display or depiction of any of the following in respect to minors. And it talks about, pubic hair, anus, vulva, genitals, nipples of the female breast, touching, caressing, fondling, buttocks, genitals, sexual intercourse, masturbation, sodomy, bestiality, oral copulation, and so it goes on to it is much more specific and narrowly, I would admit, more narrowly tailored than what you have in here. And I'm not sure, I do believe we need to, at least as it relates to material harmful to minors, we should be consistent. So because if somebody goes and looks,
I don't have an issue to putting that back in. My understanding is it wasn't necessary because it's the Miller test that sort of defines that. But again, I would be open at adding that language.
Well, I'm just thinking if somebody goes and they're looking for material harmful to minors, and one statute says one thing and another statute says something else, then which one is really going to control? And so I think we do have to have
the Miller test that, obviously is the one, but I would be open to actually working with you, going to the floor and adding that language back in. Again, my understanding it wasn't necessary. That's why we didn't include it back in, because it's the Miller test that's really the legal precedent for defining what it is obscenity. But we could certainly add those language back in. I don't think it changes the bill, but
well, I think when we have two different definitions of the same conduct, it does look. Look, I think there's some other things we probably need to work on. Again, I don't know how you calculate 33 1/3 of a website and all that, but that's we can talk about that on the way to the floor. But as it relates to this, I think this is something that's substantive that really would cause some confusion, and really, frankly, would give a defense attorney a great defense to say that he doesn't have to comply with 77, because if you go to Act 440, it says something totally different that's more narrowly tailored. So I do think you need to at least consider that.
Okay, certainly.
Okay, great. All right. So, do you have anything further you want to close on?
No, thank you so
much.
much.
Okay, the board is clear. Representative Tarver had a motion to approve House Bill 77 with amendments. Do I have any objections? Yes. We have an objection by Representative Newell. All right, we will call the roll. A vote yay is to move the bill favorable. A vote nay is to keep it in committee. All right, Miss Stephen will. There we go. Call the roll.
Thank you, Chairman Davis. Representative Davis.
Yes.
Yes. Representative Brown. Yes. Representative Cox. Yes. Representative Fisher. Yes. Representative Fontenot. Yes. Representative Gudo? Yes. Representative Green? Yes. Representative Hilferty? Yes. Representative Hollis? Representative Jordan? Yes. Representative LaFleur? Yes. Representative McKnight? Yes. Representative Newell? No. Representative Presley? Yes. Representative St. Blanc? Yes. Representative Tarver? Yes. Representative Thomas? Yes.
Yeah, before I announce the vote, I'll let you ask.
Will the considerations what Rep. Jordan put in there, if he put this in this bill, there would be no confusion. And that's what you were saying, right? Yeah. Okay. That's what you're going to do.
Yeah,
okay. Thank you, ma'am.
It was in the first bill, so it's totally fine.
Okay.
Yeah.
And Rep. Green, real quick.
Madam Chair.
Okay, it's over. Okay, I have to announce the vote. I'm sorry. All right, the vote is 15 yeas, 1 nay. The bill is passed out of committee with amendments. Thank you, Representative Schlegel.
Okay.